This is a seminar from myself, John Meredith Hardy, and Hannah Saxena in relation to the Compensation Recovery Unit Essentials and Hazard Avoidance for the busy practitioner. We hope that what we're going to say is going to be helpful. Hannah's going to start off the seminar and I hand over to her.
Thanks, John, and thank you very much, everyone, for joining us this afternoon. Just to let you all know, there's a Q&A function on the webinar, so if you want to ask a question, please do type it in. We can't see you, but we will be able to see your questions, and we will try and get round to all of them at the end, the ones that we know the answer to anyway. Compensation Recovery Unit, why is it so topical? We'll get to that. We're hoping that today can be a practical session without too much kind of history and detailed kind of intricacy in the background, but it is helpful to know what the Compensation Recovery Unit, its function is meant to be, and how that affects you as practitioners. So the background is the Social Security Recovery of Benefits Act, 1997. You'll probably hear us refer to it, if we do at all, as the 1997 Act. I actually always, whenever I have an issue and I'm struggling with knowing what to do with a CRU certificate, I go back to the Act. It's actually quite helpful, but more than that, I actually often look at the technical guidance on the DWP website, which I find quite helpful and answers a lot of the tricky questions that I have. So those are really good resources to turn to when you're stuck, but hopefully also have these slides. Now, the purpose of the 1997 Act was to, well, there are two purposes. Firstly, to ensure that the state wasn't out of pocket, so that a defendant, usually an insurer, reimburses the state for benefits paid as a result of an accident. But also the second purpose is to avoid double recovery. So to allow for those benefits to be offset to the sum paid to a claimant that reflects those benefits. Now, in terms of who needs to make that payment, that is a compensator, is the terminology used in the Act. A compensator who makes a payment is liable to DWP for total amount of recoverable benefits. That's total amount of recoverable benefits in the certificate produced by DWP. What is recoverable benefits? Well, that's defined by the Act as those which are paid during the relevant period in respect of the accident. And both relevant period and in respect of the accident I put in inverted commas because those can often cause some debate. Relevant period, less so. That is defined as either when claim is finally settled or disposed of, or maximum 5 years from the accident. So if you have a long running claim and you are beyond 5 years, you'll have noticed that the certificate of recoverable benefits. In terms of different duties on different parties, I mean, the obligation on the claimant is to provide a national insurance number, so a defendant can apply and find out the information, but really the obligation is mostly on the defendant when it comes to communicating with the DWP. So there is the CRU 1 form that needs to be sent to the DWP within 14 days of receipt of a claim. And then a request for an up-to-date certificate. The onus is on the defendant to do that prior to making a compensation payment. Then there's the duty to pay the total on that certificate within 14 days of making a compensation payment. And this is something that but not a goodwill payment before proceedings are anticipated. And that is the duty on the defendant is to pay the total payable on the certificate, even if there's an agreed liability split. Unlike NHS charges, which if there's contributory negligence, the NHS charges can be reduced to reflect contributory negligence, and also even if the whole amount can't be offset against damages, which we will come to. Now, the reason that we have a very healthy turnout on a sunny Wednesday afternoon, it is probably because CRU has become far more of an issue for both claimant and defendant practitioners in the last few years, and that will predominantly be because of universal credit and the introduction of universal credit and the kind of rolling out now. It's across the board, and really a lot of the historical benefits are being phased out. So the majority of claimants, if they're receiving benefits, will be receiving universal credit. And that the reason that makes things controversial is because certificates have increased so much. It is now not uncommon to be seeing certificates, in the tens of thousands of pounds. You're looking at, if it's a long-standing claim, sometimes certificates, 40, 50,000 pounds. And that can be a real kind of thorn in the side of a settlement. And it really can impact whether or not a claim is going to be settled. An insurer might want to, for example, where causation is denied, or there are various different arguments about claimant getting back to work, might want to just, make a lowball offer of £5,000-10,000, but they might be stuck with paying a CRU certificate of £50,000. That may well prevent settlement at a low value. So what did universal credit replace? Well, it replaced 6 benefits there in the list. And the reason it's controversial is because child tax credit and housing benefits, well, that they were not recoverable benefits under the Act previously. So now that's all rolled up into one monthly payment. There's no breakdown, so you can't separate it out. The other 4 benefits that it replaces are benefits that you would have historically seen on certificates, and they are kind of ones that supplement or replace earnings. So they're the ones we're used to seeing, but actually the addition of child tax credit and housing benefit into the same lump sum means that these monthly sums are much more than we're talking about previously. And that's why it's a problem for both parties, because a claimant may have, for example, been receiving housing benefit before an accident, before negligence, and then afterwards been out of work and had to make an application. And actually, it's all been rolled up into a universal credit payment, and that's much more, and that will completely wipe out potentially their past loss of earnings claim. Whereas part of that, they'd argue, well, that's my housing benefit that I've always recovered. How is that as a result of the accident? But you can't separate it out. Now, that is something that insurers and claimants, because it affects the damages they often get, have been grappling now with for a few years, with people on both sides feeling that it is unfair. That goes into just a quick discussion about a recent Court of Appeal case, which most of you will probably have heard about, partly because it was the High Court decision that made waves. Actually, the Court of Appeal has kind of reinforced the status quo. The Aviva insurance and Swiss reinsurance proceedings, Aviva had a substantial book of long tail employers liability, insurance, and Swiss reinsurance were the reinsurers for that, in the context of mostly asbestos litigation, where a disease was found to be divisible, and in the particular case that they were talking about, that the employer insured was only a minor contributor to that divisible disease, and the claimant was also contributory negligent. But under the 1997 Act, the insurer was liable to pay the whole CRU certificate, which was around £34,000. Aviva and Swiss Reinsurance decided to bring judicial review proceedings, saying that the 1997 Act was incompatible with the Human Rights Act. Partly because there was a requirement, and this was accepted by the High Court. So partly because there was a requirement to pay 100% of benefits when there's contributory negligence. And partly the requirement to pay 100% of benefits where others would be liable for indivisible disease, but they can't be traced. They also were arguing, but this wasn't actually properly dealt with, decided by the High Court. It thought there was potentially a breach. One of their arguments was about universal credit and the type of kind of unfairness that people generally across the board have been feeling for the last few years about housing benefits and things like that. So after the High Court's decision, it was thought that, well, look, here we go. We can challenge all of these CRU certificates. We can challenge universal credit. We can challenge in cases where there's contributory negligence. There was some excitement in the legal world that cared about CRU. But the Court of Appeal has, in January this year, overturned that and found that actually there's no breach of the Human Rights Act. And actually part of the intention of the 1997, well, part of Parliament's intention in enacting the 1997 Act is that all state benefits paid to the claimant who had suffered an accident, injury or disease were to be recovered. And that's legitimate, and it's shifting the burden to the insurers was a legitimate aim. The rationale of the 1997 Act was it shifted that burden from a claimant to the insurer, and in the kind of fair balance when considering the judicial review, it was considered, well, look, it's limited for 5 years, it's not forever, and a claimant will often get free NHS treatment that an insurer will benefit from. So it's give and take. So the long and short of it is that actually we're back exactly where we started, and it reinforces that it is what it is. There is some unfairness, particularly around universal credit, and that is, Court of Appeal, not open to challenge. I've looked and there's no mention of there being permission to appeal given or even an application to the Supreme Court. So I think things are being left as they are. And I think that's the end of the story. Having said that, and John's going to be dealing with reviews in a minute, but anecdotally, I know in a few of my claims, we've asked for a review of the certificate on the basis, so for example, a lot of universal credit applications, if someone's living with someone else who was receiving benefits beforehand, they're treated as a couple, and sometimes you see that whole amount on the certificate because it is just one lump sum amount and it's not broken down. And so we've had quite a lot of success in claims asking for a review. And often, I don't think the DWP has historically really known what to do with those review applications. And so you can get some success in cases where actually it's probably not a kind of a legal point that you can take. Now, in terms of quickly looking at offsetting, there's a helpful table attached to the Act, which I've reproduced in the slides, which list what benefit can be set off against what head of compensation. There are only 3 heads of compensation that you can offset against. The main one is earnings lost during the relevant period. And that's important because that's earnings lost during the relevant period. So that's up to 5 years. So sometimes I hear people characterize it as past loss of earnings, but if you've gone beyond that 5-year point, then that's not actually the case. Often, obviously, claims settle before that 5-year point. So it will just be past loss of earnings. And what you can offset against past loss of earnings, that whole list, but which includes, as we've already touched upon, universal credit. But it also, ESA, income support, job seekers allowance, but those type of benefits as well. Then the other 2 heads of loss that you can offset against, the first is compensation for the cost of care incurred during the relevant period, and attendance allowance and the living component of PIP. Historically, the care component of the disability living allowance. Those are the main ones that you'll be able to offset against a past care claim. And then the last is compensation for the loss of mobility during the relevant period. And that's something I'll touch on in a minute. What does loss of mobility mean? But what you can offset against that mobility allowance, the mobility component of PIP, and historically DLA. A few points about offsetting. The first is in relation to interest. So it's a slightly complicated roundabout way. You add interest before you offset, but the benefits can also be offset against the interest. In terms of past losses, so that won't include Smith and Manchester Awards, which is a general damage anyway, but won't include future loss of earnings, but can include lost pension contributions. Cost of care to include gratuitous care provided, so it's not just someone that's paid for external care. You can offset the living component of PIP against a gratuitous care claim, but possibly not. So often a gratuitous care claim is part tasks, help with getting to the toilet, help with showering, but some of it is often, help with childcare that can no longer provide, help with hoovering that used to do before the accident, that type of thing. And the commentary suggests that it might not extend that far to tasks that a claimant can no longer do themselves. And then finally, just a word on loss of mobility and what that means. So that only applies to claims that arise from a claimant's lack of mobility, and not, for example, for a general travel expenses claim for expenses incurred as a result of an injury. So, your normal mileage to hospital, visits and things like that. Often there'll be some degree of overlap there, so it may not be the whole travel expenses claim. So yeah, that's a word on offsetting, and I will now hand over to John for a bit.
Hi everyone, I'm going to speak about a number of issues to do with settlement, but just to start off with, if I may, in relation to interim payments, and it's an important point to mention. This is both with respect to defendants and claimants, for claimants to watch out for before they make an interim payment, and in relation to defendants if an interim application is made. The trap, as I've mentioned on the slide, is this. is that assuming that the grounds for an IP are satisfied, the court must not order an interim payment of more than a reasonable proportion of the likely amount of the final judgment. And as we all know, interim payments are also discretionary. But specifically, it says that PD 25B 4.1, and these are in circumstances, remembering, where if an interim payment is made, the compensator has to pay all of the CRU up to that date. And so one needs to see this provision within that particular context. It says the order will set out the deductible amount as defined by Rule 36.221D, and the payment made to the claimant will be the net amount. So importantly, and particularly in cases now, where, for example, where there may be a big issue in relation to causation, and where there might be an issue in relation to, it may not be a particularly high value claim. In those circumstances, you may find that, in actual fact, there is very little headroom for an interim payment to be made at all. That's outside of what you might call an argument to be made by one side or the other, or particularly by the defendant, obviously, in these circumstances. That in actual fact, there isn't a reasonable proportion which you could safely say should be provided to the claimant. And particularly, I would say this in the context of causation cases, because you might have an instance where, for example, it's an acceleration where it's conceded there's a whiplash for 12 months, which of course may be general damages of not significant sums, sub £10,000, and little or no consequential loss as a consequence. And so you can see how real problems can arise here. So claimants need to be aware of it being in relation to the net point that they will receive on an interim payment application if the application is made. Of course, none of this prevents an order being made by consent, but that, even if an order is made by consent, doesn't mean that the compensator, i.e. the defendant, has to make payment of the CRU sum to date, although subject to review or appeal in due course, and as I'll come on to now. So moving to the next slide, compensation, recovery and offers. So how do we see reference to those particular issues? And again, you'll be familiar with the need to be compliant with CPR Part 36 in order for any offer to be subject to its provisions. And in this particular respect, the defendant is provided with a number of mandatory obligations in relation to compensation, recovery, payments or sums, in that under Rule 36.22(3), a defendant who makes a Part 36 offer must, where relevant, state either that the offer is made without regard to any liability for recovery amounts, or is intended to include any deductible amounts. Now, it is the B aspect of it that provides the subsequent and important obligations. If it's just A, then these obligations don't apply. But defendants, generally speaking, will want to make an offer that includes reference to CRU, so that one knows what the gross sum is and what the net sum is. And so one's got something of a handle about the totality of the offer. And it's unusual, I think, for offers to be made without taking CRU into account, although, as I say, of course, that is permissible. But if, as is usually the case, CRU is taken into account, then in those circumstances, the Part 36 offer must state, and these points are mandatory, must state the gross amount of the compensation, must state the name and amount of any deductible amounts by which the gross amount is reduced, and must also state the net amount of compensation. If one moves to the next slide, I'll just summarise some of the points and relevances of those for both parties. In order to be able to achieve that outcome, obviously the defendant must have applied for a certificate, and that again is provided for within the rules. And if a certificate hasn't, in actual fact, been received, the defendant is allowed more time, but they must clarify their position so it's compliant with the preceding rule to which I just referred, within 7 days of the receipt of the certificate. And bringing CRU generally into account, as often occurs, clearly will not comply with the provisions of Part 36 and risk satellite litigation. Now, of course, there are a number of different authorities in relation to compliance of Part 36 and the effects of it. Dutton and Minard's has been quite useful for some parties in this respect. The validated possible position. There's been subsequent jurisprudence on the point from 2000 and Popplewell J, suggesting that perhaps one shouldn't be as generous as that. But nonetheless, you want to avoid satellite litigation about whether or not there has or hasn't been compliance, and therefore whether or not it is a Part 36 offer, as opposed to it being merely a Rule 44.24C fallback position, i.e. it's an admissible offer that can be taken into account by the court on the question of costs. If you don't want to have that satellite litigation and arguments, it's important and that you are compliant with the requirements of the rules. And generally taking into account is a bad plan, and very frequently one sees in Part 36 offers no substantive breakdown in relation to each one of the specific benefits and how that cross relates to the specific heads of loss. Now, Form N 242A prompts a set off of specific benefits versus specific heads of loss. So it's probably always useful in those circumstances to use the form, or if not use the form, to make certain that your standard letters that you use include, if you like, a breakdown to prompt anyone when making those Part 36 offers, to prompt them to provide that breakdown. Now, where a Part 36 offer is accepted outside of the relevant period and further benefits have accrued, the court's permission is required to accept the offer. And that's both substantively within the rules and also in the practice direction. And the court can, in those circumstances, direct a further deduction of CRU from the offer sum. So there is, if you like, a fallback position in relation to those benefits that have been that have accrued subsequent to the offer, and how they should be brought into play by reference to the rules. Moving to the next slide, and assuming that the Part 36 offer has not been accepted, looking at the question of judgment. Now, judgment is really where is significantly easier in some respects in trying to untangle some of these issues, because the rules themselves assist us as to how you should deal with the like with like comparison, and it's a like with like comparison which often is the problem, and it has faced the court previously in trying to disentangle, if you like, the position. The Crooks and Hendricks Lovell from 2016. If you're interested in these particular points, I would respectfully suggest you go and have a read of that case, where the position was put very differently by the parties as to what should be compared with what. The basic proposition that was emphasised throughout that authority, and indeed reflects Rule 36.22(8), is that it's net offer versus net outcome, i.e. it's the sum of money having taken off the CRU sum, both by respect to the offer and also in respect of the offer and also in respect of the judgment. It is that which matters, which then of course begs the question where you have an acceleration case or a causation case, or for whatever other reason there are issues that relate to how you should untangle the cost position, then how you to disentangle that, and the answer again was given in Crooks and Hendricks Lovell. First instance, the way in which it was dealt with was that judgment was given that addressed the question of causation and quantum, and then cost orders were then adjourned to after the CRU appeal in the light of the judgment to ascertain what benefits were paid in respect of the accident, injury or disease. And then at the adjourned hearing, the court then readdressed whether the claimant had failed to obtain a judgment more advantageous than the defendant's offer. And in respect of that process, that was specifically approved by the Court of Appeal. So that's your mechanism when you've got a judgment. So moving to the next slide, what about the problem areas? And of course, we all come across these problem areas, both when acting for claimants and when acting for defendants, because there are lots of conundrums as to how to resolve matters. It has to be the case that for defendants in certain circumstances, that a Part 36 really doesn't provide the preferred offer strategy. It may be that it provided an offer strategy if a low Part 36 offer had been made at the very outset. Perhaps it doesn't subsequently as the case develops, as causation, for example, becomes increasingly an issue that is well evidenced. And then in those circumstances, if one's going to be making offers to settle for settlement, which involve CRU, then you're going to need to pursue a more nuanced approach in order to be able to achieve a sensible outcome in the light of the way in which the case is put. And so claimants should expect to receive offers of this type. Defendants may think it appropriate to make them. And in those circumstances, the preferred strategy might be to make a without prejudice safest to cost offer that includes costs paid to a certain date, a CRU set off to a certain date, and then extremely importantly, that the benefit of a CRU appeal is to be for the defendant's benefit, and that all of that should be encapsulated if the offer is accepted into a consent order that sets out that agreement. And again, in relation to settlement terms, for example, if you're at a without prejudice meeting or joint settlement meeting at which the case is settled, or by offer and counter offer, but where it's subject to the terms of the settlement, i.e. subject to contract. Again, if you're going to do do offers, you need to be very careful about how the offer is structured, to make certain that both parties absolutely understand what it is they're going to get out of it. So global settlements where quantum of the CRU certificate is in issue, in other words, where it is believed that by at least one party that the CRU certificate doesn't reflect in actual fact sums that were paid essentially in consequence of the accident, but were paid in consequence of other reasons, then it is in those circumstances those settlement terms should make all of these points clear. Now that can be dealt with by reference to recitals. It can be dealt with by reference to the terms of a Tomlin order, which addresses specifically the contractual arrangement and agreements between the parties, but nonetheless it needs to be in writing, and it needs to say exactly what it is that the basis of the settlement is, what CRU sums are deducted from what heads of loss and for what period, and who is to make and benefit from a CRU appeal. Now, to all intents and purposes, as far as what some CRU sums are deducted from what heads of loss and for what period, etc., those are all matters that if you had a judgment would have to be put into the judgment. It's mandatory. It's in the CPR, has to be put into the judgment in any event. But those similar points also apply for the purposes of clarity of settlements, because if you are going to seek a review or an appeal, the basis of settlement is going to be important to be able to demonstrate that there's no inconsistency between the settlement and the basis of the review or the appeal, and more particularly, who is to make and benefit from the CRU appeal, so that there then isn't an argument as to who is entitled to the benefit of that appeal should payments be made. Particularly the latter point, on account of Bruce against Genesis Fast Foods, which did a review as to who was entitled by reference to statute to an appeal, and in that particular context, the happy beneficiary was the claimant, or notwithstanding the fact that they hadn't in actual fact had to give credit for the payment because of a sloppily drafted settlement agreement. Now, the way in which the guidance puts it is this. And this is to be found within the CRU guidance. It draws this distinction. It says, if an appeal is made by either party and the amount of recoverable benefit is reduced, then the Secretary of State will refund the relevant amount to the compensator. If there has been a reduction in the compensation under Section 8 or 8A, it's 8 that we're talking about here primarily because we're talking about personal injury, not disease, etc. Then the compensator is obliged to recalculate the compensation award and make any necessary refund to the injured person. For recoverable benefits, if no offset has been made, or the offset has been made but not under Section 8, then the compensator can retain the refund. So, as you'll appreciate, quite a lot of those settlement terms at which I've been speaking can be circumstances of which essentially are hybrid. In other words, where there's an element of a Section 8 set off, but not a complete Section 8 set off, and hence why it is extremely sensible by both parties to make it clear who is to get the benefit of an appeal or a review. So moving on then to challenging CRU, and as Hannah has already mentioned, CRU is hard-edged. A person who makes a compensation payment in any case is liable to pay the Secretary of State an amount equal to the total amount of the recoverable benefits. And that's it. So that's what will happen and must happen and will be enforced against the compensator in the event of non-payment. And that, of course, is subject to the question of challenge. And of course, one of the primary issues, as I've already mentioned, and most likely and most common basis, of course, essentially is questions relating to causation. Because the point is simple: without challenge, all CRU, all sums of money which are to be found on the certificate, will have to be paid by the compensator, by the defendant. So then, looking at the question of review and appeal. First of all, the review can be requested by either party prior to or after the final determination of the claim. They're effectively review for the reasons I'm about to mention in this pure sense under Section 10 is one which is to be addressed prior as opposed to after. And in relation to appeal, it can only be made after the claim has been finally disposed of and the CRU on the certificate has been paid. In other words, it's always an after the event exercise. And in those circumstances, it will always follow a mandatory reconsideration. As to who has the entitlement, the defendant has a mandatory right to appeal, but the claimant only if compensation was reduced by CRU according to the Social Security Recovery and Benefits Act 1997, Section 8. And again, that takes us back to the point about who receives the benefit. So moving on then to the next slide. So as far as the review process is concerned, the grounds are that a mistake occurred in the preparation of the certificate, and of course, mistakes are made, mistakes with names, dates of birth, etc. Any number of other possibilities could arise, and other muddles. And so obviously wants to scrutinise a CRU to make certain that it's natural fact it's referring to the right person and it has all the appearances of being correct. Has to be said, in my experience, is that they're less likely to overstate than to state that they're nil when in actual fact they're not nil. But in any event, there's also a ground to appeal for all those grounds under the Social Security, under the 1997 Act, Section 11. I'll come on to those. But in practice, reviews will not be successful pre-finalisation of a claim unless there is a mistake or some other non-contentious ground. If there's anything contentious, that's really going to be, it's unlikely to be successful and have to be dealt with on appeal. So it's important to note, though, that on review, the certificate cannot be increased unless this was due to incorrect or insufficient information being provided to CRU by the person applying for the certificate. So essentially it's a one-way street unless there's someone's being misled. So moving on to the next slide and the appeal process. So post-judgment settlement, CRU must be given an opportunity, first of all, to reconsider its decision before an appeal is actually made. Because now appeals are done through the first tier tribunal, and consequently, in order to reduce costs, there's a mandatory requirement essentially to ask them to reconsider first. And so that mandatory reconsideration must be requested within 1 month of CRU being paid, although time can be extended. And an appeal to HMNCTS must be made within 1 month of written reasons for the mandatory review being provided. So those are your two deadlines that you've got to bear in mind. As I say, up to 1 year you can get extensions, but it's sensible not to go down that route, but to make your first of all your mandatory reconsideration requests and then your appeal within the timelines provided by the rules. In those circumstances, you will need to provide statements of case, a copy of the judgment if there is one, and the settlement terms. And hence why here particularly I've spent some time looking at the question of settlement terms and their importance, because they are going to form essentially the substance of the kicking off, if you like, of the mandatory reconsideration of the appeal. Medical reports and surveillance evidence obviously may be very important in order to challenge issues of causation, medical causation, etc. Witness statements or other material that's been served on behalf of the claimant might be relevant to that. And obviously on appeal, the mandatory reconsideration reasons that are sought to be challenged also need to be provided. So moving to the next slide. What are the grounds? So any amount, rate or period specified in the certificate which is incorrect, I will go back to our mistake point, which I mentioned previously on a review. And then perhaps the most significant one, listed benefits which have been or are likely to be paid otherwise than in respect of the accident, injury or disease in question have been brought into account. And then most appeals are likely to be made in relation to that. And it's in respect of the accident, injury or disease is likely to be the question. Listed benefits have not been and are not likely to be paid to the injured person during the relevant period have been brought into account. This is whether the claimant was paid at all. It's not a rerun of the one above. And this might be computer errors which have misled CRU, for example. And then a payment has been on the basis of which the certificate was issued is not a payment within section 11A. And section 11A is that it is a payment that it has to be a payment which is paid in consequence of any accident, injury or disease. That's just a question of fact. It was a payment for another purpose. So then just looking at a couple of those points, if I may, moving to the next slide. So the most important ground is paid otherwise than in respect of the accident, injury or disease in question have been brought into account. Now, here, what we're talking about otherwise is referable to sole cause. And the test here that we're looking at is talking about effective causes. So if the effective cause is the accident or an effective cause is the accident, then the fact that there are other causes which may have contributed doesn't make any difference to the outcome, and the appeal will not succeed. As you may imagine, are lots of nuances to those particular points, and that they will always be fact dependent and will rely very much on the evidence. And again, it takes one back to the importance of setting out clearly the grounds of settlement, basis of settlement, the basis of the judgment, etc., bringing to bear sufficient evidence to demonstrate and prove that, in actual fact, the accident had no, if you like, contributory or other cause to either all or part of the benefits. And obviously, in most instances, what we're talking about here, although it's not always going to be the case, in most instances, it's going to be part, because what we're talking about is, for example, in an acceleration case that I've already mentioned, it will be for 12 months only, for example, and the rest of the claim, which is a lifetime claim, for example, which gave rise to the very significant damages which are sought to be claimed in the case, and which, because, for example, if it's taken us a long time to get to trial, there might be 4 years worth of benefits, and therefore very significant sums up to the figures that Hannah had previously mentioned. All of those sums, essentially, apart from that shorter period, may then fall away if it's a successful review or appeal. And this ground can also include whether benefits should have been paid at all, i.e. the claimant did not qualify for the receipt of benefits, and this would be, for example, in circumstances with health benefit fraud. What about practice points? Tribunals may sit with a medically qualified person. When medical causation is an issue, that clearly is going to be to the benefit of the other parties. Hearings can be in paper or in person, although you'll be unsurprised to hear that the latter are more successful. A tribunal is required to take into account the decision of a court on the same subject matter. And of course, if it ends up with a determination which is inconsistent with that, it might find itself in difficulties and could give rise to an appeal. And it may take into account settlement terms, but no doubt it will always be the case that the tribunals will be somewhat aware that the parties might have sought to massage the case into a certain position, which in actual fact sought to deprive the DWP of their recovery and to benefit the parties in contradistinct, and therefore be somewhat very much in their interests and not in the CRU interests. So the tribunal will be careful about settlement terms, but nonetheless, if they're properly drafted and clearly drafted, they may well be persuasive to the tribunal. But it clearly, and then as I mentioned, the tribunal is not obliged to adopt the same approach as the court. And of course, will be slow to accept an appeal which is inconsistent with deductions that are made already under Section 8. So, yeah, there's elements of inevitable common sense in relation to that. So, I think I'm now going to pass over to Hannah, and she's going to just run through some examples.
Thanks, John. I'm quite conscious of time, and everyone's already spent quite a bit of time with us this afternoon. I'd put together 2 basic examples just to talk through, so I can show very basically for those more junior of you attending how it might work in practice and offsetting. So the first example is a claimant who gets £100,000 in compensation. That's broken down as on screen. So you've got 40,000 general damages, 30,000 loss of earnings, and 30,000 travel expenses. You have a CRU certificate with incapacity benefit of 20,000, income support of 50, and DLA mobility component of 30. So in terms of how that then breaks down, the award of 100,000 less, so first of all of the 30,000 loss of earnings is offset. So as long as they're passed, because there's £70,000 of benefits that can be offset against lost earnings. Possibly also all of the 30,000 travel expenses, as long as it relates to a loss of mobility, that can possibly be offset as well. Assuming that's the case, then that's 60,000 offset against the claimant's award, and as always, the general damages is sacrosanct, so that can't be touched. So the claimant receives 40,000. The insurer ends up paying 40,000 to the claimant and 100,000 to the DWP. So that's example 1. Example 2, where you've got a liability split decision on a 50-50 basis. You have, it's an acceleration case, acceleration of 2 years. General damages are assessed on a full liability basis at 20,000, past loss of earnings of 60, and care assistance of 20,000. And you've got NHS charges of just over 1,000, 1,054, and £50,000 of universal credit. The award net of liability, so the 20 plus 60 plus 20 is 100, divided by 2, you get 50,000 net of liability, less the whole of the past loss of earnings claim of 30,000 on a net basis. That the universal credit just wipes that out. Even as I say there, if the universal credit is paid over 4 years since the accident, the whole amount can be offset. So even where you've only got this 2-year acceleration period, if the certificate hasn't been reviewed and you've settled, then the whole amount can be offset. In that case, that claimant receives £20,000. The insurer pays out a total of £70,527, which is made up of £50,000 the DWP for the CRU certificate, £527 to DWP for NHS charges, because you can halve those because of the contributory negligence, and £20,000 to the claimant. So those are some very quick examples. Now, I've been looking at the questions that have been coming in, John. The first is the maximum you can offset the amount on the CRU certificate, and the example is given where there's loss of earnings claim if the claimant receives £10,000 worth of universal credit during the relevant period, but the certificate says 5,000, can you only offset 5,000? Yes, you can. You only offset what the certificate says, because it might have been for some unknown reason that the DWP has decided that only £5,000 of that is benefits that were paid as a result of the accident. So you wouldn't be able to offset more, even if you know that the claimant has received more in benefits. I hope that answers that. The second question is about riders. So if you're waiting for CRU to remove a rider from a certificate which is nil, and damages are agreed, do you have to pay the damages and wait for the rider to be removed, or can you refrain from paying damages until the rider's been removed and then you have a valid nil certificate? I mean, if you're a defendant, you take the risk then that they'll come back. I mean, so as I understand it, a rider is usually where the national insurance number hasn't properly been connected to the claimant, and there's a risk that they'll come back and say, actually, there are recoverable benefits if they do connect it to a different person. And so you take that risk, because if you won't be able to offset as an insurer if you've agreed damages, you haven't offset any benefits, and then later on, once that rider's been removed, they come back and say, oh, actually, there's £20,000 of recoverable benefits here you have to pay, or you're not going to be able to offset any. So you lose the chance to offset. They do come back. So that's something that you would really want to hope to get sorted out before that. John, I don't know if you want to take one. There's one about practicalities regarding review and appeal. I don't know if you can see them. You want me to read it out to you?
Oh yeah, can I just say on the prior one though, you're just not going to hand over any money to anyone until you've resolved your CRU certificate. I think that's the answer. I mean, you could come to an agreement, but you're not going to make the payment until the agreement's got to say it's subject to a final certificate, and the payment is unlikely to be made, or if the payment is to be made, it's only to be made to solicitors to hold on account. They can't distribute it to the client, because otherwise you're unlikely to get it back. It might just disappear. Sorry, moving on to the next one.
So that is a question of practicalities regarding review and appeal. The DWP currently have a 6-month waiting list for consideration reviews. If the case settles in that 6-month period, is there an obligation to pay CRU, or as the review is pending, should CRU review the certificate before payment is due? If the case is settled, is the compensator obliged to pay CRU, then pursue a mandatory consideration?
Yes, as far as I know, if you're in those unfortunate set of circumstances, as soon as the case is settled, that sets a new timeline running, both in terms of the obligation to discharge the CRU certificate, i.e. for the compensator to pay the sum, and also sets time running in terms of the mandatory review. So essentially it starts a new process, and it's important that it does so, because once you start the new process with the mandatory process, once that has then been dealt with, you then have the entitlement to appeal. So you're starting, if you like, on a new process rather than the old process. Of course, it doesn't mean to say, of course, that the DWP might not have put 2 and 2 together as far as those reviews are concerned, but you still need to go. You still need to pursue the mandatory route.
I should say, anecdotally, I know they do have a 6-month waiting period, but I had a JSM recently where it made such a difference to whether or not we'd settle, and it was only kind of 3 months after a review was put in, and both sides just harassed the DWP, and eventually they not only gave it, they turned around and there was a £50,000 certificate, and they reduced it to like £317 the day of the JSM because we've been harassing them that much. So sometimes harassing them does work to get put higher in the queue. Clive, is this Clive Thomas? Clive Thomas, who used to be a member, or another Clive Thomas? Maybe there are multiple. Anyway, Clive, how do you deal with a situation where the defendant puts forward a global offer and refuses to break it down? I mean, that's going to become difficult if you're saying as a claimant, well, actually the certificate can't all be offset. If there's a possibility that couldn't be the case, then that's something you're going to have to argue about, the level of offsetting. A defendant doesn't need to break an offer down.
Well, they don't have to break an offer down as long as it's not Part 36. But if it's Part 36, they must break it down. Yeah. Because it's mandatory required that they identify exactly what benefit is being set off against which head of damages. And as far as the defendant is concerned, it's very much in their interest to do so, because particularly if causation or other issues are in play. But everyone has to make their own judgments at the end of the day as to how they think they're going to be better off. And of course, global offers also raise all sorts of interesting questions, don't they? As far as the claimant is concerned, because of course, if there had been an element of, it is clear there was a Section 8 set off within that global offer in some way, shape, or form, then in those circumstances they're entitled to the benefit of an appeal. If there isn't, then it's arguable that they are not, depending on the approach of the EWCA, though you do need to take into account that authority to which I referred to earlier on.
John, there's a last question there from Kate. Says, tactically, would this impact any advice to claimants to claim benefits or not? For instance, trying to rely on savings, interim payments, and not benefits.
Well, if they've got savings, they might well be able to achieve from those savings, possibly now, perhaps less so in the past, interest, etc. Of course, they won't have any of those benefits, if you like, if they spend it. It does seem to me that generally speaking, there isn't a claimant's not being prejudiced by being in receipt of benefits, because as long as there is truly a set off of for a claimant, there's a set off of the benefits against an actual aspect of the claim, and where there isn't such a set off, then it's essentially like for like, and there is essentially no downside for a claimant. But Hannah may have a different view on that.
Yeah, no, I mean, there's only a downside if you're talking about a claimant claiming universal credit, and that including some element of housing benefit or child tax credit that then is set off against their loss of earnings, and more would be offset than that they would recover. But the thing is, practically, this isn't ever going to be an issue, because if someone's got sufficient savings to live off without claiming benefits, then they're not going to qualify for universal credit. I can't remember what, I think it's £7,000 or something, but if you have a certain level of savings, you can't claim universal credit. If you're claiming a non-means tested benefit, well, those are kind of PIP, and those aren't detrimental at all for a claimant, because it's not the same as in a universal credit situation. So I don't really think there's ever going to be a situation where it's a problem in reality.
But as far as interim payments are concerned, yes, I mean, one would always encourage people, claimants, to make applications for interim payments, so they don't have to rely on the receipt of money from any third party. And that certainly gets rid of some of these complications, particularly in relation to some benefits, where it might be argued that some of them are paid partly as a consequence of the injuries and partly not.
Brilliant. Well, I think those are, oh, sorry, there's another question. Back to the beginning, what constitutes a goodwill payment that doesn't trigger repayment? I mean, that's usually where there's not even a kind of letter of claim. A claim hasn't been presented yet, so it's a kind of genuine goodwill. You tripped over in my supermarket. Yeah, before you've even presented a claim, here's a kind of £200 gift voucher.
Yeah, and I think we are talking about it's gift voucher territory. So if it looks like something which is a reasonable substance in light of an allegation being made, it's unlikely it's going to be one that's going to fall within the goodwill exception.
Perfect. Okay. Well, thank you all very much for joining us. Someone asked earlier if the slides were going to be available, and I replied saying yes, I think there will be a PDF that's going to be emailed around probably tomorrow now.
Thank you very much. Good afternoon, everyone.
Good afternoon.